Hello, I'm Joshua Kaufman. I'm an attorney, and in this segment we're going to be talking about copyright infringement. Plain nomenclature, copyright infringement is simply getting ripped off. Having somebody use your copyright protected material without your permission. It could be a direct copy, could be the creation of a derivative work, whatever it is. It's the illegal copying of your copyright protected work. It can come in many formats. They could be taking a little bit of it and sampling it, copying it wholesale. It could be transforming it into another medium. It's all infringing works. If you violate the rights of a copyright owner set out in Section 106, which you can get from another segment in this series, it is an infringement. Usually what happens is a copyright owner finds out that they're being infringed upon one way or another. More often than not, the first thing is a cease and desist letter. People then usually pay attention and try to negotiate a settlement, perhaps a license to continue using it or not, and parties negotiate, and most of the cases get settled at that juncture. Significant minority of the cases don't. People ignore the cease and desist letters, are arrogant about it, think that people won't really go after them, that they can get away with it, or think that they have the right to do it, that a license was granted to them, or they're a co-owner, or it's a fair use, or whatever other type of defense they may raise. And if they prevail, they prevail, and it's not an infringement. But all infringement cases, if you file suit, are federal cases. It's always a federal lawsuit because the copyright law is a federal law and it preempts any other type of law. So every copyright case is a big to-do. It's a federal case. They can be very expensive to litigate. But basically what you have to show in a copyright infringement case is that they infringed on your works. They didn't have the right to do it. Now you have to bring a copyright infringement case within 3 years of the time the cause of action accrued when they started infringing on your copyrights, or if it's been a continuing infringement from up until 3 years before they stopped. If they're still doing it, but they were doing it for more than 3 years, you can only get damages 3 years back, even though the infringements continued more than the 3-year period. If you had filed a copyright registration prior to the time the infringement began, you're entitled to have your attorney's fees paid by the other side. It's in the court's discretion, but they often give them, and statutory damages. Statutory damages are very important. There are two kinds of damages, and we're going to look at them: regular damages and statutory. Under the regular damages, which we sometimes call actual damages, they're broken into two parts. One is your lost profits if you're the copyright owner, and the other is the defendant's profits. So your lost profits is what you can show you would have made but for the infringement. Often that's just going to be the royalty that you would have been paid, unless you can show that you lost specific sales. On the other hand, you're entitled to the defendant or defendants' profits that are attributable to the infringement. Copyright is a strict liability offense. So the fact that somebody says, well, I didn't know I was infringing, I didn't know it was protected, I got it from somebody else and they told me they created it, it doesn't matter. Everyone who touches in the stream of commerce that infringing work is separately and jointly liable. So that would be the factory that manufactured the infringing goods, that would be the importer if that's the case, it would be distributor, and it would be the retailer. All who sold the work would all be liable to the copyright owner. And each of them would have to disgorge their profits. So even though the manufacturer may have hypothetically made $20,000, the importer may have made $30,000, the distributor $80,000, and the retailer $200. Well, you add all those up, and that's what the copyright owner is going to be entitled to. But many times, that amount that you can show you lost or you stopped the infringement early on, it's just not going to be that much. Copyright infringement litigation can cost hundreds of thousands of dollars. So if you don't have a copyright registration and you're confronted with a case where the infringers made $20,000, $30,000, $40,000, $50,000, and if you have to go after them, it could cost you $100,000 to $200,000. it's a chilling effect on enforcing your rights. So it's a reason we keep talking about you want to register your copyrights so you can get that. Now, if you file a copyright infringement suit and you lose, the other side, unlike other situations, can get their attorney's fees. So you have to be careful not to file a frivolous copyright claim, because if you lose, you could pay the attorney's fees for the other side. These cases are often settled at different points in time. No one likes to be sued, but you have to be very, very careful. So the key takeaways here for copyright infringement are: I don't know, I didn't know is simply not a defense. You want to have a copyright registration to make a claim economically viable. You have defenses: I had a license, I'm an owner, or it's a fair use. But copyright infringement is federal lawsuits. They're expensive, and if you can avoid them, you really want to do it, so don't infringe.